Hello everyone, this is Dr.R.BRINDA, Assistant Professor, PG and Research Department of Commerce, SHREE College for Women Autonomous, Salem. In this video, I am going to discuss about the topic Discharge of Contract in the subject Business Law. First, let me explain the meaning of business law. Law refers to the set of rules and regulations framed by the government to safeguard the people and avoid exploitations. We come across various laws like civil law, criminal law, company law, and so on. In the same way, business law refers to the rules and regulations formulated to safeguard the people or parties involved in the business. Business always dealing with many people like producer, buyer, seller, consumer, partners, government officials, general public, and the people who are directly or indirectly involved in the business regime. In this case, there may be a chances of conflicts and misunderstandings. In order to avoid all these complications and exploitations, Indian Contract Act 1872 framed this business law. Now let us move on to the main topic, discharge of contract. Are you heard this term discharge anywhere? Yeah, I captured a voice, that is hospital. While admitting a person in a hospital, it is termed as admission, and relieving a patient from the hospital, it is termed as discharge. In the same way, entering into a contract is called formation of contract, and relieving or terminating from the contract is called discharge. Thus, discharge refers to the ending of the contractual relationship between the parties, that is, offerer and acceptor. The people enter into the contract, breach the contract, and terminated it by n number of reasons. The parties no more liable under the contract after the discharge of contract. The discharge of contract may be done in the following various modes. First one is discharge by performance. Second one is discharge by mutual consent. Third one is discharge by impossibility. Fourth one is discharge by contract by operation of law. And the last one is discharge by breach of contract. Let me explain one by one in detail. It is the usual and natural mode of discharge of contract. That is, when both the parties completed their performance, the contract comes to end. That is, the promisor and promisee fulfill their obligations and mutually agreed that considerations, the contract automatically comes to end. The contract was discharged by the proper settlement between the agreed parties. This is called discharge of contract by performance. Second one, by mutual agreement. So mutual, the word mutual refers to deliberately or non-deliberately they agreed upon the terms and conditions. If both the parties agree their conditions and comes to end to the contract, then it is called discharge of contract by mutual agreement. The mutual consent may be in the form of novation, alteration, remission, rescission, waiver, and merger. First one is novation. Novation means substitution of new contract in place of the old one. It creates a new contract in exchange of the old contract. It discharges the old, that is the original contract, with the new one. The new contract may be either between the same parties, that is the parties who already signed in the agreement, or between different parties, that is with the new party. The consideration being mutually discharge the old contract. For example, the contract between Alexa and Inisha. Alexa owes Inisha rupees 10,000. Due to financial issues, Alexa was not able to pay the debt. On behalf of Alexa, Sarah agreed to pay Inisha rupees 10,000. With this novation process, both Alexa and Inisha agree that Sarah will take over the liability. Now, Sarah becomes the responsibility to pay the amount. This is called novation. Second thing is alteration. Alteration of a contract means change in one or more of the terms of a contract. Alteration is valid if it is done with the consent of all the parties to the contract. In such a case, the old contract is discharged. Suppose if the alteration is being a fraudulent one or it exploited the other party, then it is not a valid one. So always alteration must be agreed by all the parties who are involved in the signing of the contract. Next thing is remission. Third one is remission. Remission, as outlined in section 63 of the Indian Contract Act 1872, the promisee accepting a lesser fulfillment of the promise, such as accepting a smaller sum than the originally contracted, is called remission. Example, if A owes B rupees 5,000 and B accepts rupees 2,000 full satisfaction or full settlement, then the contract is discharged by remission. So in remission, every promisee may dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time for such performance, or may accept instead of any satisfaction which he thinks fit. Fourth one is rescission. Rescission means cancellation of all or some of the terms of a contract. For example, by mutual consent, the parties cancel the terms of a contract or cancel few of the rules and regulations of the contract, then it is called rescission. Fifth one is waiver. Waiver means abandoning the rights. When a party to the contract abandons or waiver his rights, then the contract is discharged. Last one, merger. Merger means two things or terms joining or coinciding with one another. Here, the meeting of inferior and superior right in one and the same person may be merged. That is, inferior right availability under an agreement will vanish automatically with the superior rights. Thus, superior things extreme in the contract, whereas inferior rights disappears in the contract. It is called the merger. By these circumstances, the discharge of contract comes to an end, and it is called the discharge of contract by mutual consent. Third thing is discharge by impossibility. It is clear from the term itself, impossible. So it is not even possible to do the action, or it is not possible to perform the contract. The contract is discharged when it is not possible. This is because the parties cannot perform their respective obligations due to some reasons. The impossibility of performance may be of two types. One is impossibility at the time of agreement, and the other one is impossibility arising subsequent to the formation of contract. Next one is discharge of contract by operation of law. It may occur in the case of death or insolvency. First one is death of the promisor result in termination of the contract in case of the contract involving personal skill or ability. In other case, the rights or inabilities of the deceased person pass on the legal representative. Suppose if a person enters a contract by with a skill or any special talent, then it will be comes to end if a person dead. In other cases, apart from skills, it may be passed to his legal representatives. Next thing is insolvency. Insolvency means the person not able to pay his debts. Here, a contract is discharged by the insolvency of one of the parties to it when the insolvency court passed an order of discharge exonerating the insolvent from liabilities on debts incurred prior to his adjudication. That is, if a person is insolvent and it is expressed by the court order, then the contract automatically comes to an end, that is terminated. Next one is breach of contract. In case of breach of contract, the aggrieved party from performing his obligation is relieved. That is, it may arise in the form of anticipatory breach of contract or actual breach of contract. First, you have to know what is breach. Breach means it is the when one party breaks the terms of an agreement with between two or more parties. This includes when an obligation that is stated in the contract is not completed on time. For example, if a person late with the rent payment or when it is not fulfilled at all, such as tenant vacating their apartment while owing 6 months back rent. So in these cases, one party willfully exploiting the other parties. This misconduct is called breach of contract. Anticipated breach of contract occurs when a party repudiates it before the time fixed for performance has arrived, or when a party by his own act disables himself from performing the contract. It is the premature destruction of the contract. The term premature indicates that is anticipatory before the term. So it is called anticipatory breach of contract. Next one is actual breach of contract. This type of breach of contract occurs when a person does not perform as part of the contract at the stipulated time. Here, the person who failed to perform his part will be liable for its breach. In case of such breach of contract, the parties can get remedies. That is explained in this topic, remedies for breach of contract. Parties to a contract are expected to perform their respective promises, but one of the parties to a contract may break the contract by refusing to perform its promise. It is called breach of contract. In this case, the party who is affected by the breach of contract by another party can get the remedial measures. These remedies can be of various types, namely suit for rescission, suit for damages, suit for quantum merit, suit for specific performance, and the last one is injunction. First one, rescission, where one of the party to a contract commits breach, the other party may treat the contract as rescinded, that is cancelled. On this rescission of the contract, the agreed party is discharged from all the obligations under the contract. That is, he is no more liable or obligated to the another party under the contract. Second one is suit for damages. The term damages means monetary compensation payable by the defaulting party to the agreed party in the event of the breach of contract for the loss suffered by him. The damages may be of four types. One is ordinary damages, second one is special damages, third one is exemplary damages, and the last one is nominal damages. In the first case, ordinary damages, it is also termed as general damages. These damages are arises in the ordinary course of events from the breach of contract. Second thing, special damages. That is, these damages are payable for the loss arising on account of some special or unusual circumstances. That is, they are not due to the natural and probable consequences of the breach of contract. Then the third one is exemplary damage. This is also called vindictive damages. That is, these damages are awarded against the party who has committed a breach of contract with the object of punishing the person in order to compensate the agreed party. Generally, these damages are awarded in case of action on loss or breach of promise. For example, breach of contract to dishonor the check without any proper reason, then the person may incur exemplary damages. Last one is nominal damages. Nominal damages are arrived to the aggrieved party when there is only technical violation of the legal rights. That is, the loss is very nominal. Nominal means small value. Here, no substantial loss is caused. These damages are very small in amount. Hence, they are termed as nominal damages. So, these are comes under the category of suit for damages. Then the third thing is shoot for the specific performance. Sometimes the damages are not an adequate remedy for breach of contract. In such cases, the court may at the shoot of the party not in breach, direct the party in breach to carry out his promises as per the terms of the contract. This is known as specific performance. That is, the court direct the other party to perform his obligations which are signed in the contract. Then the fourth one is suit upon quantum merit. Quantum merit means as much as you earn. So in that sense, the payment to be made to the exploited party in proportion to the work done or in proportion to the amount earned by the other party who is exploiting the other one. This is like the compensation to the injured party. Then the last one is shoot for injunction. The term injunction may be defined as an order of the court instructing a person to refrain from doing some act that has been the subject matter of the contract. Where a party has promised not to do something and he does it and thereby commits a breach of contract, the aggrieved party may seek the protection of the court under circumstances and obtain an injunction. So, an injunction is a court order that compels an individual or entity to do, refrain from doing, or to stop doing a specific thing. That is usually here the term stay order. So, this is a stay order which stop the other party in doing the activities which are exploiting the other party. This is called shoot for injunction. So, these are the various remedies for breach of contract. So, as a nutshell, in this video, we discussed the meaning of discharge of contract and that in detail the breach of contract and remedies for breach of contract. I hope now you all clear with the terms which are involved in the discharge of contract. Thank you for your patience listening. Thank you.